Thanks, Liz. Yeah. Okay, let's get that going. Welcome everybody to this Tuesday morning. This is a 2-hour core class, and it will be on the REPC. Hopefully we can all be a little bit wiser after we've traveled through the next couple of hours, even if they're just reminders or if it's brand new information. Just to remind you of those division rules. Obviously have your name displayed on the screen and have your video turned on, of course, and be seen and engaged throughout the class. Hopefully we can all engage with each other as we go through the next couple of hours. We do need to be here for the whole of the class. And of course, I'll give you those 3 key words, which will pop up when I show this little icon. That's our little poodle, Merlin, and he pops up, the keyword will flash on the screen. And at the end of the class, Leslie Ann will share with you a form that you can submit those keywords in and submit the form in and get your credit. So today we're going to talk, it's one of these Raising the Bar classes, which was created by Jennifer Yo, who's our principal broker at Presidio. And we have 12 in the series, and this is the one on the REPC. She has said this: irrespective of how much we might get paid on a transaction, our overall objective from the outset should be to give 100% of our efforts to our clients to ensure a smooth transaction. Hopefully we can do that when we're working here in this real estate industry. I found this interesting quote from 6th US President, John Quincy Adams. He said, if your actions inspire others to dream more, learn more, do more, and become more, you are a leader. And hopefully we can become more as we study and increase our education within real estate. I know we have lots of seasoned realtors with us today. We also have perhaps some new realtors. So please share your ideas and thoughts and stories, questions. I believe that we learn a lot from each other as we share experiences that we've had with those of us particularly joined the industry or maybe renewing their license. Irrespective of how long we've been a realtor, I believe we all can learn in this industry and we can become better realtors and serve people better as we understand more of what we're doing and engaging with people. We'll look at 2 things here. We'll look at the REPC and contract law. Well, first of all, just review contract law so that we're all aware of that, and then we'll go through the REPC in detail. Please just unmute and chime in with any comments you have or any questions. I'm totally happy for you to literally unmute and just interrupt me. I will not respond to any chat through this presentation. Leslie Ann will respond to chats, but I'll just keep the full screen going so that we can all at least see these slides.
Can I just ask a question?
Yes, thank you.
Can you see me? It's Elizabeth.
So
yes.
It's Elizabeth. Okay.
Yes, I can see everyone except for Darren.
Okay.
And I am trying to work with him on getting him on camera.
Okay, good. Because I can't see anybody else. So
Can you see the screen?
Yes.
I can see the screen. So
That's
good.
all you need to see. Yeah.
Okay.
No, you're fine. I can see you.
Good.
I always let people know if I can't see them so that they don't think
Okay.
they're being seen and they're not.
Okay, thank you so much. Appreciate it.
Okay.
Yeah, I can definitely see you. And also, when you do chime in, just say, your name first so I can see you, because I can't see everybody. I can only see a few pics when I'm running full screen. So just introduce yourself and say, I'm Elizabeth and I've got a question or experience or story or thought. So at least we know, or at least I know who's speaking to me. So let's look at the contract law and then we'll go through the REPC in quite detail. There's quite a lot in this REPC. And, it's good to review it as we go through the property, the purchase price. We'll look at settlement and closing. We'll go through the prorations, obviously the disclosure, confirmation, title insurance, sales disclosures, identity. A lot of pieces to this particular contract that sometimes I don't realize how involved it is, right through to the home warranty, final walkthrough, changes during transaction, authority of signers, complete contract, mediation, default attorney fees, government notices, and no assignment, insurance risk. Time is of the essence. Electronic transmissions, acceptance, contract deadlines, and finally the time for acceptance of the offer. So there's a lot in that REPC agreement. We'll try and get through all those in the next couple of hours. So first of all, let's look at contract law. and see if we can remind ourselves what this is. Contract law is a body of law that relates to making and enforcing agreements. Contract is an agreement that a party can turn to a court to enforce. Contract law is the area of law that governs making contracts, giving them out and fashioning a fair remedy when there is a breach. So we basically have kind of 5 main pieces of this. Obviously, we have the offer. And in contract law, it can be a verbal or written promise. In real estate law, we only work with written promises. Take some action to refrain from or acting in exchange of return rees. And we've got the acceptance, which is explanation of acceptance, including expiry dates, rights of revocation, and appropriate forms of acceptance. We've got a consideration. We're going to look at it. Each party will bring whatever value they can to that contract to come ultimately to a binding agreement. And finally, the other part is competency and capacity. Make sure that both parties are legally competent to agree to the terms. So they're kind of the 5 main basic principles of contract law. In this country, what is the age for a legal adult? Do we all know what that is?
21.
21,
18.
Definitely. You can
18.
even get going a bit earlier. 18, yes,
18.
Absolutely. 18. Think about that. So in the United States, 18-year-old is considered a legal adult when a person reaches the age of 18. A sufficient stream of income and good credit, they are actually legally able to go in or to enter a contract to purchase real estate. So an 18-year-old actually can buy real estate. Here's some interesting questions to think about. First of all, if we've got a client who's an 18-year-old, can they get a mortgage? Do we know the answer to that? Yes, they can. However, there are some conditions. So let's just look at those. Of course, they need to have an adequate stream of income. And, you know, if they were self-employed, they'd really need 2 years of income, which means they may not be able to get that unless they were started employment before they were 18. Good credit scores are pretty important for an 18-year-old, and generally speaking, loan companies won't look at any 18-year-old unless they've got a credit score of 620. Let's just pause on that for a moment. Some of you are thinking, well, how can they get a score of 620 when they get to 18? Generally speaking, I know a bit about this because obviously I've come from England, been over about 13 years. When aliens come in, we start on, believe it or not, we start on a 999, which is quite exciting until you do something and it goes down to 250, which is more or less what the 0 is, which an 18-year-old would get. They would, if they started, or any youngster starts credit, it will start at 250. There are a number of families or parents that will bring in or add to any current loans or credit cards or moving of credit. They'll add a minor on their account, which will enable them to start their scoring, which means they can get to that 620 by the time we get to 18 if you're doing that. We do have a particular course on that in one of the Raising Bar series, so we could go in that more detail if you wanted to, but you could have an 18-year-old that could get that 620 score if they started earlier on, being attached to their parents' credit scores. Obviously, there needs to be a limit on other debts, and generally speaking, loan companies won't look at it unless we are less than that 43% of total income. Down payment needs to be anything from the 20% conventional loans right down to the FHA loans, which can go down in some cases to that 3.5. Any questions on those items on that slide? And finally, that other area there, obviously an 18-year-old could have a parent or a grandparent or someone else be a co-signer on the loan. So if you're working with a youngster and they ask you that question, the answer is yes, they can get a mortgage. And there are some conditions, as there are in everybody that wants to loan money. And there are some of the platforms that you would need to be aware of. Has anybody here actually done a transaction with a young person of 18 or similar age to that for real estate? Very good. Okay, let's move on. Let's look into the REPC. and see how we get on with this. So first of all, if you notice at the top of that agreement, we've got in bold capital letters, real estate purchase contract, and underneath it says, this is a legally binding real estate contract. Utah law requires real estate licensees to use this form. That's us. Buyer and seller, however, may agree to alter or delete its provisions or to use a different form. If you desire legal or tax advice, consult your attorney or tax advisor. So this is a legally binding real estate purchase contract for Utah. I'm sure we all have used it. Those who've been in the business long enough and are fully understanding that we do need to use this form. We can't kind of create our own. We can adjust it as we go through the transaction by using, you know, addendums or whatnot. So in some cases, we may work with a builder or another entity that may have a different form. And that's fine, as long as it complies with Utah state law. And of course, if you want any legal advice or tax advice, we always invite those that need that to consult their own tax advisor or an attorney. Let's tuck into the earnest money part and let's have a little talk about that. So you've got a client and you're looking at buying a home, well, they're looking at buying a home, and let's say the home is $400,000 and your client says to you, how much earnest money do you think we should give? Let's have a discussion on that first. Anybody like to respond to that question? Obviously the answer is depends, but who would like to tell me how they might deal with that question? I have to pick on someone then. You've all gone quiet on me. Let's bring in Tiffany. Tiffany, how are you doing today? Do you want to unmute and say hello to everybody?
I'm good. Can you hear me? I should be unmuted.
Yeah, you're good. How long have you been a realtor for?
16 years.
Yeah. Oh, you'll know lots of options on this. So if you've got a client, Tiffany, and they've never done it before, they're really interested in this house, maybe it's $400,000, and they say, well, you know, what earnest money do you think we should be looking at?
Well, you know, back in a few years back, it was usually people were putting down about $1,000 earnest money. But in today's competitive world, you have to put down a lot more than that just so that, you know, the sellers take the buyers seriously. I mean, I would encourage, you know, anywhere between $1,000, $5,000 for a home that's, you know, $400K.
Yeah, so it does depend. And in this particular market, as Tiffany just said, and stay with me, Tiffany, in order to, you know, present some really good faith will that you are going to buy this home, you may have to increase your earnest money because there is not an awful lot of inventory on the market. And so you've probably got other people that are also looking at that same property. I've always thought similar to what Tiffany said. I thought usually around that sort of percent margin, you know, $4,000 for a $400 house is probably a good rule of thumb, but maybe more because we're in a climate of low inventory. Well, what are some other things that we might explain to our client about this earnest money? Because sometimes they don't quite understand the protection that the earnest money has. So would you like to answer that for me, Tiffany? Talk to me about what protections they have with this earnest money. Are they going to lose it? You know, is it, you know, how's this going to pan out with this transaction?
Well, I've never had anybody lose their earnest money, thank goodness.
That's because you're a good realtor. Good realtors do not lose earnest money. Very good.
Yeah, you know, you have to let your clients understand that they have to meet those deadlines. The deadlines for the appraisal, for the due diligence, and make sure that all of that they're meeting all of those so that the earnest money doesn't get lost. And if they're staying within those parameters, then they're going to be safe with however many thousands of dollars they're putting down. But, you know, people do lose their earnest money. I mean, I've heard of, you know, other realtors where the earnest money gets lost, and it's unfortunate. But like I said, in today's market, we have to put down a little bit more to show the seller that we are serious about purchasing the home. If someone puts down a $500 earnest money deposit or $1,000 even, it's just not enough to compete with others who are willing to, you know, lay down, put more skin in the game, I guess. I don't know if that answers your question, but.
Yeah, that's perfect.
Not,
Yes, fire away, Elizabeth.
the thing that's hard now is now they want your earnest money to go hard upon acceptance. I mean, when you're in a bidding war, that's, to me, that's been a big problem. Or they want you, if you pass the dates and stuff, that, you know, they want you to leave some earnest money on the table if you end up backing up. That's been really hard in this market.
Yeah, certainly for the smaller homes, you know, which are moving very, very quickly, or have been moving very quickly in the last couple of years. You know, there is an increased desire from sellers to see some earnest money going hard. But of course, you know, our client needs to make sure they're happy with that, and understand that if things don't work out the way they need it to work out, that money is then at risk to be lost. Of course, if it goes hard, it is lost. So yeah, make sure you have a good chat about the earnest money. Make sure our client understands how much they're going to put down, and you know, as Tiffany said, you know, it's totally protected on to keep within those deadline dates. And unless, of course, you know, as Liz just mentioned, it's going to go hard. They understand it's gone. It's gone. Whatever happens to the contract if they're running hard. Let's ask another question. Talk to me about this little set. Oh, anybody got any other questions on that, or responses, or thoughts?
Stephen,
yes.
Stephen, this is Diane.
Hello, Diane. How are you today?
I'm good. Another thing too, I think the earnest money, the amount they put down, is protection for the buyer too, in case the seller defaults.
Yes, very
so,
good. Very good.
You know, that is something to tie in this market too. You know, sometimes the seller receives a higher offer and they want to pull out.
Yeah.
First one. So I think it's a protection both ways.
Yes, it is. Yeah. The more earnest money that's in the pot from the buyer, then there is obviously more commitment from the seller, because that is also, they should be in a position to compensate for the same if things are going to go rough. And, you know, if things do go rough on these transactions and it ends up in court, then there's a lot more money at stake. You know, people could lose a lot more. So hopefully we want to make these contracts run nicely through the hoops. Talk to me about this. Maybe Diane, you can just stay with me. Talk to me about this 4 calendar days to have this earnest money delivered. What does that mean?
Well, you said me, right?
Yeah, yeah.
Just that the earnest money has to be delivered to the brokerage within 4 calendar days. And the earnest
so if I get that earnest money on Friday, what's my deal? When's that got to be with the broker?
Well, for me, it would be on Monday, as soon as you could. Friday, if you could.
Yeah. So, yeah, we are including the weekend. So notice It says there, agrees to deliver no later than 4 calendar days after acceptance. So if I got it on Friday, be Saturday, Sunday, Monday, Tuesday would be the very latest, very, very latest. I've got to make sure I get that in to the broker. Very good. All right. Anybody else got any comments or thoughts on that slide?
So question, so the day of acceptance, you count that very day. I always sometimes wonder if you count the next day, but you count the very day of acceptance for the earnest money.
So
if you're accepted on Friday, yeah.
So if I got it on Friday, agrees to deliver no later than 4 days after acceptance. So I got it on Friday, so it'll be Saturday, Sunday, Monday, Tuesday. Tuesday is the very latest day.
Okay.
But as Diane said, it's a good idea to work within 4 days, counting the day you get it, just so you've got a bit of grace in case you mess up a little bit. So it is 4 days after, but just make sure when you're working with weekends, you are including the weekend. Just make sure also on this form that offer reference date is what we're going to refer to throughout this transaction as we are adding to or taking away from this contract. When we do addendums, we're going to be using that date as our reference date.
I have a quick question.
Yeah, thank you.
So I know it depends how the offer is written, but if your buyer's money did go hard and the seller does back out, does that mean the buyer still loses their earnest money?
So let's just make sure I understand your question correctly. They've put some earnest money in, the buyer has. And do you say the seller backs out?
Yes. So say it's non-refundable because that was what, you know, either we wanted to do a competitive offer or the seller requested it. But things, you know, per se, let's say things go south and the seller decides, I don't want to sell the house anymore. Then is the earnest money refundable to the buyer?
Well, it would be refundable to the buyer because the seller's pulling out, but the buyer would be able to sue the seller because the seller's breaking the contract. You understand that? Anybody had that experience? Yeah. Anybody had an experience like that where the seller's pulled out and then the buyer has the opportunity to sue the seller because they are now in breach of contract?
Stephen, this is Diane again. Yes, I'd had that experience where we went all the way up to, I had the buyer and we went and signed and the seller just didn't show up.
Wow. Wow.
Decided he didn't do. And, you know, my clients, they could have sued. They decided to walk away. He was kind of a shady character and they just didn't want to get involved and get on his bad side. So
right.
They could have.
They could have sued him, but yeah, it is a bit of a hassle to do that, but they could have sued him. But that's amazing. All the way to the end, didn't turn up. Wow. Okay. Yeah. You'd be surprised what you see in this market sometimes, or this industry, I should say. Okay, let's look at the property. A few things on this. Just make sure we really understand when we're filling this out. Let's make sure it's absolutely clear what we're agreeing to. It's easy to get tax ID number, make sure that's in there. Make sure you describe the property correctly. Sometimes it may not be described correctly with the information you give them. So check it out with tax data, make sure you got it correctly identified. It's really important. Look at this 1.1. It says here, included items, unless excluded, obviously. The sale includes the following. It goes through a lot of things here. It talks about plumbing, heating, conditioning, fixtures, solar panels, ovens, you know, ranges, cooktops, dishwashers, ceiling fans. It goes through a load of stuff here, okay? Now, there may be some other things that it also includes, which is not listed here. So make sure when you read this, we can figure out if there's anything else that's also included, because we're gonna have to obviously add that too. But this is making it easy for us to start somewhere. And basically we're saying this property includes all of these items. Unless we're going to state otherwise. As we go through this little section here, you'll notice we've got a little bit of some options here. The following items are presently owned and in place of the property, being left for convenience of the parties, also included in the sale. So notice here it says washers, dryers, refrigerators, microwave ovens, and they've all got a plural S on there, which means these are all of them that's at the property. So it includes not only the, you know, the refrigerators in the kitchen, it also includes the refrigerator that's down in the basement, and it also includes the other refrigerator they've got in the garage. So just be aware when you're checking these boxes, you're absolutely clear what is included in the home, because you want to get this right from the outset. You don't want to be down the track taking over the home and realize there's an item that's being forgotten about or being taken, and that causes a challenge. Anybody have any experience on that where they've either represented the buyer or the seller and not all items have been left as they should be? Yeah, Elizabeth, just chime in. I did actually see.
Yes, okay. I had the experience a couple of years ago when we were the buyers. I was representing the buyer, and it said on the MLS thing that the refrigerators, plural, were included. And so, of course, we thought that meant the basement refrigerator and the one in the kitchen on the main floor. Well, the seller's agent disagreed with that, and I didn't want to make a big deal out of it. So the seller's agent agreed to just split a new refrigerator with me for my clients in the basement because his client wanted the refrigerator in the basement. So yeah, so I know now to talk verbally to the agent as well before everything at the end.
Yeah, our job as a realtor is to make sure our client fully understands the contract. And also, as Lily just mentioned, it's a good idea to make sure that the other agent understands where we are on this. Sometimes we may be dealing with an agent who's only just got their license. Sometimes we may be dealing with an agent who's had their license lapse for a while. They've come back into the industry. They're not quite thinking what's going on. Sometimes we might be dealing with an agent who has another day job and is not totally focused on this for whatever reason. So let's just make sure that all parties understand what's going on, because it really is frustrating and quite difficult sometimes to tidy up when we get to the end of this journey if we've not got the items that have been agreed left in the home or taken from the home. Very good. Excluded items, let's make sure we make that absolutely clear. What is excluded? Sometimes they may say, you know, these are actually excluded. These curtains or drapes that, you know, my great-grandma made and I'm taking them with me. So make sure we highlight that clearly if we've got some items that are not going to be included in this sale. Before we go into the water service, any more comments on what's included in the home? All right, let's talk about water service. Some things we need to be aware of here. Can anybody talk to me about how important it is that we understand how to fill this little section out? I have to pick on someone. Stephen, how would you like to chime in on this one for me? Talk to me about the water service.
What questions do you have?
So yeah, say for instance, I'm your client and we get to this and maybe I'm in a rural area and you're going to talk to me about water rights and water shares, and maybe I don't know if I have them or not.
Well, I think first my job would be to, if I'm representing the buyer, I would talk to the seller's agent and find out exactly what water rights are available. And if I had any questions at all, I would talk to the appropriate governmental entity, the city or the county, perhaps even the state, just to determine exactly what rights go with this property so that I could adequately inform my client what they could possibly be purchasing and explain that to them.
Perfect. Stay with me, Stephen. If for some reason the seller did have water shares, could they keep the water shares and still sell the home?
I suppose, well, I think aren't they conveyed separately, so that I'm a little unclear on this, but I'm thinking they could have to be conveyed separately, so a seller could perhaps retain them.
Correct.
Please correct me if I'm wrong on that point.
You're right. You're absolutely right on that. So it's not automatically necessarily that water rights are always going to go with the property. So it's another kind of real estate transaction to move those water rights over, or water shares generally is what we've got. Very good. So just make sure you understand this section, make sure that your client is fully aware. Often in the cities, this is not an issue because, you know, they don't have water shares or water rights, but generally in your rural areas, you may come across this.
Yes.
And that's where you go to get your extra help. Yes, Stephen, carry on. Did you just say something then or not? Did I miss that?
No, thank you.
Perfect. But as Stephen just mentioned, you can contact Utah Division of Water Rights and find out, you know, what has been administered or appropriated for that particular property. It's quite easy to do that. Okay, let's go on to, there's our first little keyword coming up. So let's pull that up. You want to jot this keyword down. It's going to be water, W-A-T-E-R. Should be on your screen now. Just shouting out at you, water will be the first keyword. So write that down, because I will not mention it again, and we cannot share it in chat. So it'll just be mentioned once, but water will be the first keyword on this class today. All right, let's go for the purchase price. And who can tell me how important it is that we try and fill out as much as we can on this section if we're representing the buyer? All right, who can we bring in here? What about Kristen? How about you chiming in and saying hello to me today? Is Kristen able to? How are you today? How long have you been a realtor for?
Only 3 years. So I am newer to this, and I do it on the side. I am a school teacher, and I kind of do this mostly for friends and family. So
perfect. Well, you got through that 2-year barrier. A lot of realtors don't make it through the 2-year hit. So you're on the 3 years. Well done.
Yep.
Super. And it's super that you got into this industry to, you know, bring in a bit of revenue and help folk. But you've also got another job as well. So well done on that. Let's talk about this little line up here, Kristen. So how important is it for you to try and get as much information in here as possible when you're trying to present a REPC, to a seller?
Well, obviously the numbers are very important. And when I do these, I will check and recheck and check again and add and subtract and do it backwards and make sure that I have it all correct.
Perfect. It's really important to do that, to just make sure that purchase price at the bottom is the total of lines A to E.
Right.
And, let's try and get that information. We may not have it exactly right, but for a seller to look and see, what the earnest money is, maybe there's some additional earnest money, but what the loan is, and how much cash is coming to settlement, that's really helpful for a seller to make a wise decision. Some realtors get a little bit lazy on this and they just put in the earnest money and the total price and off they go. Whereas Kristen just said, it's a really good idea to make sure you get all those pieces in there and make sure you add them up correctly. It is a bit frustrating when you get one of these when you're representing the seller and they just don't add up because the realtor's just not spent enough time adding them up. So perfect. Thank you very much, Kristen, for that, sharing that. And let's see what else we got then. We move to our next little section, which is sale of the property. So the ability to purchase the property may be, and usually is, often dependent on someone selling their home. And certainly in this particular market, if you've got an offer that's come in and it's dependent on that buyer selling their home and they've not even listed their home yet, and how many of us have to deal with a client like that before it becomes quite frustrating, because now we've got to quickly get that house sold fast, and maybe you're not going to be the first the first one on the list for that seller to choose. In this market, and obviously we're in this market at the moment, which is a seller's market, how important is it if we're working with a client to make sure that they at least have their house on the market? Or have we got anybody here who've got clients that want to buy their home, but they've not even got their house on the market yet because they want to see whether or not they can find the right home? Anybody like to talk about that?
Steve, I have one right now, actually.
Who's calling?
This is Mandy.
Mandy, far away. Thank you.
I've had bronchitis, so my voice is a little not 100%. So I have a client right now that they are actually relocating out of state, and they've been kind of dragging their feet about listing their house just because they don't feel like it's ready. And I'm actually going over there this afternoon, to try to talk to them in person to be able to explain that we can get it on there and make it contingent on him for sure getting this job. So the reason they're wanting to wait is he has to do a physical for this new job. And so it's not 100% set in stone, and they're a little nervous about listing it. But yet if he passes this physical next week, they have to be there by April 1st. And so it's making my crunch time, pretty tight to get that sold if we wait because he has to wait an additional week to find out if he for sure has the job. So I'm still almost 2 weeks out of him knowing 100%, but yet then I'm only going to have very limited amount of time to get it sold for them.
Okay, so what are some of the suggestions we might give a client like that? And you've got the client, Mandy, so let's talk what we can do, because obviously
well, I'm up for suggestions, obviously, but so the hard thing with these guys is they are kind of a really close family friend of mine, and I've made it very clear to them that we can make it contingent on him, you know, receiving this job offer and everything going through, so they're not homeless. You know, I've explained to them that there's ways that we can do that.
Can I ask a question? Are they definitely moving? Are they definitely going to be moving, or is that contingent on the job?
It is contingent on the job.
Okay. All right. Well, in that case, then he's probably going to have to wait, you know, because he can't get into any contract because it's contingent on. If they were definitely moving, they are going to be moving whether he gets the job or not. Then an option will be to say, look, let's get the house on the market and let's get it going. If we got a fast buyer in before, you know, the new employment was in place, we can always, you know, from the outset ask that buyer if we could rent back a couple of weeks to give them a little bit of buffer room there. But that only works if they're definitely moving. If they're not definitely moving, then really they're probably not going to get into a contract until they are 100% sure. Anybody else got any thoughts or comments that might be able to add or help Mandy on? Yes.
I have my 2 cents. So where is the property located?
So the property is in Orem near UVU.
Okay.
It's in Chambray, just off Geneva there. And then they're moving to Wyoming. So they want to move, but he of course has to have a job in order to move. And if he's got to do this physical and pass this physical, which, I mean, he doesn't feel like there's going to be a problem of passing it, but I guess you never know, you know.
Right. Go ahead and contact me privately, because I probably have a solution for you.
Okay.
Perfect. All right, let's move on then. If we can, obviously, if you're in a situation like that, if you are representing the seller and they need to move quickly, make sure you do price the house to sell, because that can also be a challenge if it can't move on the market, particularly in a buyer's market. All right, let's see. We move to this settlement and closing. Settlement and closing are two different things. Who can tell me what the difference is between settlement and closing? Who we've not heard from today? Let's see. Leslie, you still with us? Would you like to comment? I have a Leslie down here.
I am with you. Good morning.
Wonderful.
Hi.
How are you doing today? How long have you been a realtor for?
I'm sorry, what was that?
Yeah, how long have you been a realtor for?
Only a year.
Perfect. You're ideal for this question. have you had any transactions take place yet?
Yes, I've got one. I've had one successful, really great closing, and I've just got a buyer now. So this is great. This is perfect timing for me. I'm working on my REPC right now for a buyer.
Oh. Perfect. So what's the difference between settlement and closing, as you understand?
Is tough. Settlement is it the signing of the papers? Right. And then closing is when it actually goes through the bank and is complete.
Perfect. Yeah, just make sure that our clients understand that these in Utah, they're two separate kind of things that happen. You know, if you're in Colorado, you know, generally settlement and closing happens at the same time. It all happens in one go. And in some states, that's the case. But in Utah, we're going to all meet together with the title company and we're going to sign all the forms and all be happy. And then we're going to wait for a number of hours. Sometimes it's a table closing, can be reasonably quick, but often it's going to be the next day. Closing will take place usually within the next 24 hours. And that's when the funds are transferred and then the title has also transferred at recording. So Just make sure your clients understand that that is the way it works here in Utah. It isn't happening all the time. They don't walk out and say, we've now got our house, where's the keys, let's walk into it. It's more a case of we've now settled, which is great, and we're just waiting for it to close. Sometimes, unfortunately, a transaction can fall through between settlement and closing. Has anybody had that happen on this class, where they had a transaction fall through between settlement and closing? Anybody like to share that experience? I've had one. Anybody here had a transaction fall through between settlement and closing? Anybody like to tell me how it might fall through between settlement and closing?
Hey, Stephen, this is Diane again.
Yes, fire away. Thank you, Diane.
This situation where it was a young buyer, and he came in and signed, the seller signed, and he had failed to let anyone know that in the previous week he had lost his job. So it fell apart. Settlement, they all signed, but it didn't pass that last check. He'd lost his job. So
yeah, thanks for sharing that.
Insurance money.
Yeah, often the lender, you know, if they're a little bit concerned, they'll often call the employer, say, you know, is Johnny Jones still working? So no, he left on Friday, and that's a bit of a problem. So yeah, just make sure your clients understand that it's not all done and dusted at settlement, but it is pretty close.
Stephen?
Very good. Yes.
Stephen, it's Christy. Hey, I just wanted to mention something too, that a lot of buyers think that settlement, they get the keys at settlement. So I've had to actually talk to my clients, and both, because I'm mostly a listing agent, and I have to tell them, don't give those keys until it's funded and recorded. And a lot of them say, well, we signed the papers, that's settlement, we're done. No, it's not. So I just always have to make sure that don't give those keys too early, because if something happens between settlement and closing, you're in big, deep doo-doo.
Yeah, Christy, thanks for sharing that. You know, it's also a lot of other bits and pieces in that pot as well. Often you will have a buyer say, oh, you know, can we just have the keys and put our stuff in the garage? And then the sellers, oh yeah, we'd like to help you out. Okay. But of course, then we move into insurance platforms, and we move into a whole load of mess if it all goes wrong. You're far better just to say, I tell you what, let's just wait until this is closed. You know, one of the nicest phone calls we all get is when the title or escrow officer calls us and says, Christy, it has funded and recorded. You go, yes. And then you call your client, and then you figure out how you're going to work with that, the other agent, to get the keys to them. That's the best way. So,
we had a flood happen between settlement and closing. Wow. That was about a year ago, and it was not fun. So we had some issues. So yeah, don't give the keys.
Yeah, perfect. Now, if you're working with a new build, and sometimes with a new build, if the lender that the purchaser is working with is the preferred lender of that builder, often the builder will give you the keys at settlement. That is probably one of those minor exceptions where the builder, it's the builder's call, of course, but if they're pretty confident that all is going to go through it, and they're kind of holding most of the cards, then sometimes you can get the keys at settlement if you're working with a new build. But certainly with existing homes, we'd certainly counsel you to always hold the keys until it has funded and recorded. Good, thanks for highlighting that. And when it's closed, it has closed, and that's wonderful because we all get paid. I just mentioned, those of you who are new in this industry or early on, just make sure you have all your documents tidied up so that when you're working with your brokerage, you can get paid quickly. You know, you don't want to be playing around with trying to find different documents when it's closed. You want to have that done all beforehand. So as soon as that's funded and recorded, your brokerage is ready to process your transaction so you can get paid.
Hi, Stephen.
Yes,
I have one other experience. This was, I represented a buyer. The seller, it was a short sale home, so it was a few years ago, and everyone had signed, and the night of signing, there was a big windstorm and there was a lot of wind damage to the roof. In fact, almost the whole roof came off. Luckily, the bank had kept the insurance up on the short sale home. And so we told the title company not to record until we worked out who was going to make all the repairs in the home. So that happened between settlement and closing.
Wow. That's unbelievable.
I know, that's crazy.
Wow. Very good. Thanks for sharing that. Just one other little question here. You'll notice the last little line here. The actions described in 3.2, B and C, shall be completed no later than 4 days. That's 4 calendar days after settlement. What happens if for some reason that settlement doesn't happen 4 days? Sorry, that the closing doesn't happen within that 4 days after settlement. Who can tell me what we have to do then, or what happens? Anybody got any thoughts on that? We've done settlement, but the funds on the title have not been done within that 4-day period. Anybody got an answer to that one? Chrissy, I can see you thinking. What do you think?
Haven't had it happen, so I've never really thought about it, to be honest with you. I would say it just kind of voids the contract. There is no contract.
So the title do have some strings on this that they can pull. Sometimes there may be a delay of funds and it's going to hit the 5 or the 6 day. But often what will have to happen, you'll have to have a little addendum in there just to extend it. If the title company can extend it, if they can't extend it, and often they can't, then you'd have to do settlement again. You'd have to do an extension to the agreement and do settlement again so that we're doing that 4 days. But I do know that title have some little rules that they can work depending on what the situation is. But just be aware of that. We had it happen once and everything worked out fine. But the whole thing doesn't collapse, not necessarily. You have to work with title on it and either extend that settlement date or depending on what they can do, sometimes they can do it within their framework. But generally speaking, we've got to hit within that.
So would you extend your settlement date or the closing?
You'd have to extend, they'd have to do the settlement date again. So you'd have to extend the settlement date with an addendum and they'd have to go in and re-sign. And it depends on the nature of the beast they're dealing with. If it's a real simple one, or all I know is sometimes they can extend it a day or two, depending on what the circumstances were.
Okay.
All right. So, but other than that, you'd have to do settlement again. Good. Okay, let's move on. Let's see. Okay, we've got that bit done. Let's toodle on to possession. Okay, this is a good little section. Who can tell me about this section? We'd like to have a crack at this one. If I pick someone. Who hasn't spoken yet? Let's see, Rose, what about you? How about you coming in on this one? Talk to me about possession.
Hi.
How are you doing today?
Oh, I'm just fine and dandy. You're not going to get much from me. I just passed my test like 2 weeks ago. So
oh, perfect.
I've got my reps sitting right here in front of me, following along with you.
You're the perfect person for us to have with us. And we all clap and say, well done for passing that test. Because we all know what it's like. We all know what it's like. It's a killer. For me, coming from England, and in England, the real estate is totally different to over here. I mean, it's completely upside down. Over here is a much, much better system. In England, everything works through a solicitor and everything has to work on chains. You know, you could have 19 transactions. They all got to close on the same day in order for it to happen. I mean, it's a real pain over there, but people don't move very often. Over here, it's a much better system. But the jargon's different. And I remember looking at those tests and thinking, I'm never, ever going to pass this thing. It's just like Chinese to me. So well done for passing that test. And welcome to this industry. It's a fun little industry. So stay with me on this then, Rose. Let's look at this and see if we can learn a little bit. So here we've got possession, and we've got some options here. the possession can be on recording. So as soon as it's funded and recording, then the buyer gets the house, okay? And the seller has lost the house. So it happens as soon as we hear those words, fund and recorded. Or we've got some other options here. We could put in there, well, we're going to have it so many hours after the recording, or maybe so many calendar days after the recording. Why do you think we might have the option to choose those other two options? What circumstances do you think, Rose, we might be in to choose a different possession date or time?
I would think maybe when the sellers can be out of the house, or when it's convenient for them, back and forth between the buyers and sellers, what works best for either of them.
Perfect. That's exactly what it is. Sometimes people have some situations or circumstances, and both the buyers and the sellers agree. They say, yeah, the buyers say, yeah, we're okay. Well, you know, for you to be out, you know, within 3 calendar days after, because of whatever's going on. And in that case, we would then obviously click in this section, that little checkbox, and put the amount of calendar days that we were talking about. So it just gives a little bit of more room, a little bit of flexibility in the contract if we need to use those options. Anybody got any thoughts or comments or stories they'd like to share on that screen?
Back to me, I guess, because this question was actually on my exam, is the boxes are always in front. I checked the wrong box because I was thinking it was after if that makes sense. So that's my mistake.
I'm glad you mentioned that, Rose, because that's exactly my problem. When I came over here, I would always think the boxes were after. In England, that's the way we do them. We do the item and the box. But I noticed over here, it always seems to be the box first. So very good to highlight that. And it is easy to miss it. I think the good thing on this form, they do have that little line that's by those 2 boxes where you're asking for hours or days after, which can help us make sure we've got the right box there. Good, thank you. Let's move on. I put a note on there. When the deal is done, that's when the buyers get the keys. I think that's what Christy said earlier. So well done on that. Let's toodle on. Prorations and assessments. Okay, this is a real simple area. And thankfully, we've got good title companies that really help us on this. Who'd like to tell me what this little section's talking about? Who we've not heard from yet? Let's see. Darren, how about you chime in? Are you still with us?
I am.
Perfect.
So the proration assessments have to do with typically if there's transfer fees when you're dealing with HOAs, and if there's any assessments that go with those, like if there's, say for example, a condominium association has a special assessment for roof or for parking lot. Those are part of that section there.
Perfect. And talk to me about those little boxes, Darren, in 4.2. So we've got some options here. Who's going to pay for it?
Let me make those bigger. So yeah, there's the option of the seller paying that, the buyer paying it, or both, splitting those. And again, it's all part of the negotiation.
Yeah.
Depending on who I'm representing, I'll try and get the other one to pay it.
Right. Well, we try and be fair in everything we do and we represent him, but just make sure that, as Darren said here, that we understand what needs to be paid for, and if it is going to be split, this is the section that we would tidy up on. Now, stay with me, Darren. You'll often find in this contract these 3 words at the very end. It's not on all of them, it's on some of these sections, and it will say, shall survive closing. Do you have any idea what that means?
Well, that means that, so the contract, once we close, then the contract is done, with the exception of anything that survives closing, which is actually a separate contract in and of itself.
Yeah. Perfect. So basically it's saying, you know, if whatever's been agreed here and when we close this contract hasn't been paid, well, it will still need to be paid. We're not wiping it clean. This particular section will survive closing, so we'll still have a responsibility to fulfill whatever it is that we've agreed to do. Very good. Let's move on to this other little section. And do you want to stay with me on this, Darren? Are you happy to stay with me on this section?
You bet.
We talk a little bit about some of these on the other bit. What's the difference here we've got here? We've got a few different pieces of the puzzle here that we're going to talk to our client about. What's this bit talking about? We talked about HOA fees.
Yeah, I've got on my phones. I've got to make it bigger.
Okay. Just while Darren's doing that, just be aware that some of these HOA fees can be high amounts of money. So make sure that from the outset, we know what we're dealing with, and we know who's paying for what, and we know what those payments are. And in some cases, for a seller, there may be some percentage of the selling price that needs to be paid as they move from one ownership of the HOA to another. Yeah. Okay, Darren, fire away. What else can you highlight here that might be helpful?
That's like what they do out in Daybreak. They have that 0.5% fee that they charge when the ownership changes. Also, if you're purchasing, say for example, as an investor, you're purchasing a rental property and you have to honor the leases and all the monies in that have changed hands have to transfer as well from one to the other, and same thing with your HOA fees, deposits, any of those things have to transfer to the new owners.
Very good, thank you. Anybody got any questions on this section? It is pretty clear, but any got any questions? And you'll notice that little 3-word line, shall survive closing, is all over this page. Okay, it's all over this page on every little section. Okay, we all good on that one? Very good. Let's move on. Confirmation of agency disclosure. What on earth is that? Who'd like to help me on that one? Who have we not heard from today? Let's have a look. Aaron, what about Aaron? Are you able to chime in on this one for me?
Sure. Can you hear me okay?
Yeah, perfect. How are you doing today?
Okay, doing well, thanks.
How long have you been a realtor for?
A little over a decade.
Oh, you probably know all about this then. You'll be definitely going to help those of us who are new on this game. So talk to me about this section. How important is we get this right?
Sure. What exactly would you like to know?
Well, the section is called Confirmation of Agency Disclosure. So what are we talking about in here? What have we got to get right in here?
You're basically just stating who is representing whom. So you have your seller's agent, seller's brokerage, buyer's agent, buyer's brokerage. And they've actually changed this in recent years. Before you didn't have to put down license numbers or anything like that. So they've gotten a bit more detailed, I guess, just to make sure that it's crystal clear on the representation, because it is important, as we all know.
Perfect. Yeah, they did bring in the license number recently in the last few years. And obviously it'll populate your own license number when you use the form, of the Utah Real Estate website. But just make sure you understand which boxes you're checking here. And as Rose said earlier, make sure you're checking those boxes before the words. Talk to me, Aaron, about things we might need to be aware of or concerned of or careful if we're going to be checking that box that says both buyer and seller as limited agents. Talk to me about that.
Well, I mean, by the time you're filling this out, it should be already pretty clear what the representation is. I guess in terms of this section, the work needs to be done before you start filling out the contract, because, if you're a seller, for example, or a listing agent, and a buyer wanders through without an agent, wants to put an offer on the house, you need to make sure to ask if they are already represented. You know, things of that nature. You want to make sure are clear before you're filling out the contract, so you know exactly who to put down.
Is there anything I've got to be aware of if I'm going to be representing the buyer and the seller as a limited agent? What are some of my restrictions or concerns that I need to be aware of?
Oh boy, stay away. That's what I would say. I'd steer clear of dual agency if you can. Why
would that be? I totally agree with you, but why would that be? Helping our new agents understand.
It just okay. I personally went through this as a buyer. I bought some property in another state just a few months ago, and there was a dual agency situation, and it actually caused the deal to fall apart. The problem is that if you're representing both buyer and seller, it's very difficult to stay neutral, and there can be conflict of interest. And so if you do decide to go that route, be clear to both buyer and seller that you do have to remain a neutral party. And you're essentially just a middle person passing messages back and forth without giving inside information. So that's what I would say about that.
Excellent. Anybody like to add to or comment on that? Darren's just highlighted for us the difficulty on dual agency or limited agency.
I agree. I don't like to be a limited agent or do the dual agency myself either. So I agree with was it Darren?
Yeah,
Aaron.
Yeah. Very good. If you have any concerns, talk to your broker. But obviously, if you are limited agent, then you know everything you know has to be all shared or non-shared. Basically, you can't give something to one party and not to the other party. So, as Aaron quite rightly said, it's a good idea to have another agent represent the other party so that you are all comfortable in representing your client fully. Very good. Let's go on. Let's go to title and title insurance. Who'd like to talk to me about this one? Who have I heard from today? Priscilla, what about you? How would you like to chime in and say hi to everybody?
Hi.
How long have you been an agent for, Priscilla?
I would say about 9 years, but I really focus more on the investment side of it.
Okay, great. That's good. What are some of the highlights you might share on this little section about title and title insurance?
Title and title insurance. I mean, if you're representing the buyer, you want to make sure the title is clear, that there's no encumbrances or anything that would be a negative thing on the title that would affect the buyer. That's all done, you know, through the title company and making sure you review that prelim report, etc. As a seller, you want to make sure you have a marketable title to your buyer, that it's free and clear, and that you are actually the seller and you have the right to sell the property.
Perfect. You know, and our title companies are really good at this. This is what they do. So make sure you're locking with them early, get them assigned early to your transaction so they can make sure that everything is looking good. Sometimes on these forms, you've got kind of 6 pages here. You'll notice these buyer initials and seller initials that are in between a paragraph or a broken section. Just make sure you get all those signed, and make sure that your buyers are just signing that one little section. How many of us have had it when, if we've dealt with a hard copy, original copy, and we find out the buyers have signed the initials in the buyer section, and also signed the buyers section in the initials for the seller section. So just make sure that all the buyers' signatures have got to go in that little section there. It's an easy one to miss if you don't make that clear to your client. Anybody else had that happen? I've had it happen a few times, so just thought I'd mention it. Okay, but obviously each page has to be signed at the bottom, okay? so each page is, you know, clearly being understood by both parties. Okay, title insurance, of course, we like talking about title insurance because title insurance is pretty expensive, but it's very, very important because what it does, it insures the property for lots of misdemeanors that could happen down the track. Anybody like to comment on how important title insurance is? God, I have to pull someone in there, won't I? I've got to try and get you guys responding quicker. Let's see. What about, is it Laurie? We haven't heard from you today. How about you chiming in on this one? Is Laurie there? Oh, maybe she isn't there. Maybe I spelled her name wrong. Let's see. Who else we got in here? Anybody want to talk to me about title insurance? Or maybe she's not with us anymore. Okay. All right, and I'll have to pick on someone. Stephen, how about you? I know you'll be able to help me on this.
Well, title insurance will protect you against claims that you that would interfere with your full use and enjoyment of the property that perhaps you had not foreseen. Protects you, as your slide shows, from financial loss sustained from defects in the title to the property. And so it's something that we recommend that our buyers purchase.
It's actually mandatory, isn't it, Stephen? We have to have the title insurance, and it also will last indefinitely. You know, if down the track somewhere someone finds out that, you know, there was some fraudulent, I guess, activity on the title of the property, that title insurance will cover us. So very good. Yeah, thanks for that.
I have a question for you on this. Does anyone have any knowledge about how often these policies are paid on? What's the claim rate?
Good question. I have no idea, but I do know they have claims that come through.
The reason I asked the question is you mentioned that it's expensive, and generally normal insurance, for example, car insurance or property casualty insurance, the rate of insurance is relative to the amount of the claims paid. So I'm wondering, based on the price of the title insurance, there must be some pretty you know, frequent or hefty claims that are paid out, and it would be interesting to check into that and get some more information why they're so high.
Yeah, good question. I actually don't know the answer to that. Nobody else knows the answer to that one, but that's a great question. But yeah, it is mandatory that we have it, and it does protect us. And there are, as Stephen just mentioned, there are claims that go through, and it price, I suppose, when it does go through. Very good. So that's section 2. Let's go section 6.2. Sorry. Let's go to seller's disclosures. This is a great section. This says, it's interesting here that the wording, because it clearly says the seller shall provide to the buyer. So the seller shall provide. They're not may provide, or, you know, thinking of provide. They're definitely going to provide all that is needed in this disclosure section. So who'd like to tell me about this disclosure section? Who have we not heard from today? I think we've heard from everybody now. Let me just check my list. Yeah, just about got everybody. All right, so let's have Christy. Christy, want to talk to us about this one? There she is. I know Christy will know about this.
Sorry, I was on mute. Sorry.
That's all. Talk to me about this, Christy. How important this section is, and what are some of the things we've got to be, you know, sharp on?
Oh gosh, everything. Especially if there's hidden costs, you got to make sure that, you know, like for HOA fees, you got to make sure you've got those CCRCs and all that kind of stuff given to you ahead of time. Anything to do with property damage that you are aware of. I mean, there's just so much in here. And I always, in the very bottom where it says other, I always put any and all deemed necessary by buyer, because if there's something that's not listed up there, I always want to, I mean, if there's something that just happens to come up out of the blue, then I have that right to ask for that.
Perfect. That's a great comment. Great comment. Yeah, so let's make sure that we help our clients understand the importance of this. The seller has to disclose everything. And if we are representing the seller, of course, and the seller says, hey, Steve, the basement was flooded about 15 years ago. We've been in this house 25 years. It was flooded about 15 years ago. I've no problem since. Do I have to disclose that? What would we say?
Yep.
Yes.
Yep, that's right. We have to disclose it. Yeah.
You know about it, you say it.
Exactly. If you know about it, you disclose it. And that is for the protection of the seller. The seller is protected because they've disclosed everything to the buyer. The buyer then has the opportunity to go through that 7-page document that's the seller's disclosures and look through every single line and be aware of what they are buying. They are fully understanding the history of and condition of this property they're buying. And because they understand, yes. Yeah,
Steve, I just want to make another comment. Because I'm mostly a listing agent, I always make sure that my sellers know that if you don't disclose something, it comes back to hurt me too. It's not just you that's going to get in trouble. I'm going to get in trouble too. It's my what's the word I want?
Well, your credibility and your license.
Yeah, it's my ass that's on the grass. So
yeah.
So
Yeah, and you know we have a duty to be ethical, honest, true in all of our activities as a realtor. But you're absolutely right. You know, our credibility, but our license is also, you know, on the mark.
Yep.
Okay. And if you are representing the seller, when it comes to disclose, I'd encourage you to have that conversation and get that form in front of them as soon as they sign that buyer broker agreement, so that they've got a head start on it. And you know, often you can have that supplied to the buyer very quickly, or even before they look at the home. But have it done, because there's a lot of questions there for the seller to respond to, and sometimes it may take them a little, you know, it may take them a few hours or a few days to get all their answers. So let's make sure we're good with sellers' disclosures. And if you're representing the buyer, of course, make sure they read everything, because they are going to sign on the bottom of those sellers' disclosures that they have understood what has been shared. And so that protects both parties. Any other questions on sellers' disclosures?
I just had a comment on those sellers' disclosures. I was representing a buyer and she worked as an insurance agent. And when the sellers' disclosures came to her, when she and her husband were looking them over, she double checked everything. And she called me and said, did you know that the sellers had a fire in their kitchen? And I said, you're kidding me. They didn't disclose that. And she said, no. And so I had to call the selling agent and say, hey, you know, my buyer, she's an insurance agent and she looked at this house and did her due diligence, even with the seller's disclosures, to see what insurance claims they had pulled. And she noticed that there was a fire in the kitchen. And so what ended up happening is they called me back and said, yes, there was a fire in the kitchen, but it was in the garbage can. But the point is you have to disclose everything. Otherwise, the buyers get leery of trust issues. And what else am I not seeing? What else are they not disclosing? And so it's just always best to err on the side of honesty and make sure that you disclose everything.
Yeah, that's a great story, Tiffany. Thanks for sharing that. You don't know who you're dealing with there. They're dealing with an insurance person there, had access to all that information. Yeah. And of course, you know, the agent and the seller would feel, they'd feel a bit sensitive on that, wouldn't they? Because basically the buyer had found them out, you know. Mm-hmm. So yeah, very important that we disclose everything. Thanks for sharing that. Okay, just one little note I didn't highlight, but in there, if you notice on B, if you are dealing with a property that's built prior to 1978, make sure that we've got the lead paint disclosure, but also got the little pamphlet that goes with that when we're sharing that disclosure. All right, so let's go to the conditions of the purchase. It house might look like that, and hopefully it doesn't, but we are still going to be talking about whether or not we're going to buy it as is, or it's going to be conditioned on some buyer's due diligence. Who can talk to me about this little slide? There's a question for you. So if you're representing the buyer, which hopefully you are, if we're dealing with REPSI here, and we're talking about the dates, and the question comes out, well, how much time have I got to have some due diligence on this? What might be some counsel or some suggestions or some thoughts you might share with that buyer?
I always used to do 2 weeks, but now that the market is so competitive, I've cut it down 10 days, 9 to 10 days. So anyway.
Okay. Is that you, Elizabeth? I can't see everybody.
Yeah, that's me, Elizabeth.
Okay. So just stay with me, Elizabeth. I also saw Mandy wanted to chime in, so we'll listen to her in a moment. So Elizabeth, what may be some challenges here? You know, if you say, 10 days, what might be a challenge for the buyer?
Well, just to make sure they can get it all done. But I've learned that mostly the minute it's accepted, I feel like they can get it done. If they just, if we get the inspection lined up, everything lined up, and we just get right on it, I feel like we can do it in 10 days, just to be more competitive. So I haven't had a problem with a 10-day due diligence. So
perfect. You just need to make sure that you have got access to, if they're going to have a private inspector go out there, that you can get that organised within that time frame.
Right.
But a couple of weeks I've always worked with a couple of weeks. Usually we can get things done quickly enough within that time period. But as you say, sometimes in a competitive market where it is a seller's market, you might want, if you can, tighten that up a little bit, because that's going to make it, more attractive. But just make sure they've done their homework beforehand, that they can get an inspector in there. Because the worst thing to do is say, yeah, we can do due diligence in a week. And you think, I'm going to put a week down there because I want it to look attractive. And then the contract gets accepted, and then you can't get an inspector in there. And then you're having to ask the seller for another week because your inspector's too busy. So just be aware of that. Let's put in, I think Mandy, I did see her on mute there. Yeah.
So I've always told my clients that this is their homework time, that this is our time to find out, what we need to know about the home and if the home's going to work for them. And with the whole home inspector, I've even in this market with how crazy it's got, called the home inspector prior and tried to basically get penciled in case our offer gets accepted, to be able to tighten those deadlines a little bit more.
Good. Stay with me, Mandy. What may be some of the concerns we might have if we've got a very keen buyer, and they say, and I do actually know of buyers that have had this experience where they've been rejected. They've had a dozen rejected offers, and now they're so desperate. They say, look, I know the house looks a bit rough up there, but we're just going to buy it. And we want to check that box that says it's not conditioned upon buyer due diligence. How would you help your buyer just be sure that's the route they want to take? What may be some of the counsel you give them?
Well, for me, I always tell them that, you don't really know the insides of the house, like inside the walls. And I just explain everything that a home inspector is going to do. And, that they're going to check basically every nook and cranny of that house, top to bottom. And that, if it's the money, sometimes I will try to, usually with my closing gift, I'll say, I usually will give you a closing gift. I'm happy to give you, a gift card at the end of closing to help kind of pay back, some of this if the money is a concern. But it wasn't me personally, but my broker, she had somebody that they went in and they weren't going to do a home inspection, and she ended up talking them into it, and they ended up finding about $60,000 worth of damage behind the walls that they didn't know about. And so I've used that kind of as an example of, you know, this happened to my broker, you know, that is my boss, and you know, that I look up to, and, you know, she's one that helps guide me in my career. And, you know, they weren't going to do this, and she talked them into it, and they ended up backing out of that purchase. You know, it ended up saving them quite a bit of money, even though they lost the $350 that they paid for the home inspection.
Very good. Yeah, great story to share. You know, if the house looked like that one in the picture there, then I guess we kind of know what we're buying. It's pretty visual, but often it isn't. And as Mandy's quite rightly said, that sometimes there can be things that we cannot see, and we need some help. But if you notice the wording in this section A, it clearly says condition of roof, walls, foundation, plumbing, electrical, mechanical, heating, all the fixtures, the appliances, and it goes on to talk about anything to do with utility costs or convicted sex offenders, or anything to do with this property. You're waiving that right, okay? You're basically saying, we're good to go. So it's always your client's decision. And sometimes we have seen in this market where clients have thought, you know, I've got to get in a house, so we'll just take it and we'll take the chance. And that's totally their call. But just make sure they understand what they're waiving. Okay, let's move on. Anybody got any questions on that one? Move on to the next. Oh, yeah, there's our second keyword there. Let's pull that up. How are we doing on time? Oh, I've got to move along a little bit. Having too much fun. So the second keyword is going to be conditions. So C-O-N-D-I-T-I-O-N-S, conditions, C-O-N-I-T-I-O-N-S, conditions. The first keyword, if you missed it, talk to Leslie Ann privately. I can't share that again. But we have already had that first keyword, and that is the second keyword, condition. So jot that down. All right, so buyer's right to cancel, resolve. What about this section? Okay, sometimes it is time for us to say goodbye on transactions. So let's talk about this. Who'd like to talk about this for me? Who'd like to chime in on this one? You all got such good ideas. I like to hear your stories. Let's see, we're not there for a while then. Let's see what we got here. I can call anybody, you know, but what about Diane? Let's have Diane again. She'd probably help us on this one. Are you there, Diane?
I am.
Perfect. Talk to us about this. What did we learn on this little section?
Well, if they can cancel during the due diligence period up until that due diligence time, if they find reasons that they want to withdraw or cancel the REPSI, you know, and they can get their earnest money back. But if they let that date go by or not respond, then no longer can they withdraw for a due diligence reason.
Yes, perfect. So we're very careful on those deadline dates, make sure that we are squeaky clean. You know, put them in another calendar so you're up on it, because your client may not be up on it. It's our job to make sure we're within those deadline dates and we keep everything tidy. And just to remind everybody, when we talk about a deadline date, we are also talking about a deadline time on those dates. And what time is that here in Utah?
Time is of the essence.
Time is of the essence, but there's an actual time of the day we've got to be thinking about. We look at those
time of the day.
5 p.m.
5 p.m. 5 p.m. Yes.
Well, just really, you have to send the cancellation over by 4:59. If you don't, 5 o'clock is too late. I learned this the hard way.
Tell us a story, Mandy. I've got a story to tell. That sounds like a good story. Tell us.
Well, I have an investor that puts in a lot of offers on homes, and this home in particular, he decided the day of due diligence that he wanted basically $20,000 off the price. So wow. I reached out to this other agent, and this other agent, you know, basically it was after 4 o'clock. I said, you know, we have until 5 o'clock. If I don't hear back from you, you know, we're going to have to send over a cancellation. And she's like, well, you need to give me time to talk to my client. And I reached out to my broker because I had never been under that. I've been an agent for for 3 years, and I'd never had somebody want $20,000 off the price after 4 o'clock. So, you know, day of due diligence. And so, long story short, she was like, you need to give us some time. Like, I think we can make this work. And I talked to my client, and he's like, well, you know, I want the place, but if they're not going to take the money off, then I'm not going to do it. And I'm like, what I should have done. And I will say, I lost his earnest money just because of this. And I kind of got backed up against a wall. Me and my client wanted to give them the opportunity to be able to talk it over, and in good faith, basically felt like, you know, we were doing the right thing. And I explained to him that if they decided, you know, that they didn't want to do that, that we were risking the earnest money. And he was okay with it verbally on the phone. But the next day, when they came back later after it wasn't the next day, it was later that evening after 5 o'clock. She said, well, my client doesn't want to take the $20,000 deduction, and now you've lost your earnest money if you guys back out. Then my client basically kind of got upset that I had lost his earnest money, even though I had very verbally explained to him that if we didn't send that cancellation over by 5 o'clock, that we were risking that. And taking that chance if they didn't, you know, accept that new deduction. And me trying to keep my client happy, I gave him back his earnest money. I mean, it was luckily only $1,000, but that could have ended up costing me quite a bit of money, you know, in the end. And come to find out, there are some agents out there that like to do this because they know that they can win your earnest money over. So just be careful, because it happened to me and I never thought that it would, you know, but it was a hard lesson to learn.
Yeah. Well, you'd actually advised him correctly. It was his fault. He lost his earnest money.
Yeah. And that's the hard thing, is it kind of ended up becoming my word against his, because I know that I had advised him that, but it wasn't worth the $1,000 to potentially lose this investor that has used me before. And so that's why I decided to just pay it back to him and keep him happy.
Yeah. If you're in that situation again, the ideal thing will be to confirm in writing your conversation, and do it by email and text. So they've got it 2 ways, and then they know exactly that, you know, you counsel them correctly.
Well, and Steve Perry explained the other way that we can do it too is, hey, you know, like this is basically, you know, we're asking for a $20,000 price reduction. If, you know, under any circumstance, we don't hear back from you by 4:59 p.m., Correct. Consider this our cancellation. So, you know, kind of a tough way to learn, but, you know, it happens.
It does. We had a client years ago, actually. It was a piece of land, an expensive piece of land, $250,000 the land was. And $5,000 earnest money came in. And the agent cancelled 3 minutes past 5 p.m. and lost $5,000. And my client, I was representing the seller. He says, no, he said, lost their earnest money. He was wise enough to know that they had lost his earnest money. And believe it or not, it happened the same with the same client 2 months later, but they didn't care about their earnest money. They just changed their mind. But the first one, they did care about. The agent had messed up there, and that was a chunk of money to lose. So just remember that, you know, of course, people got an opportunity to cancel. Make sure it's done in writing. And if you're going to cancel before those deadline dates, make sure that's clear and it's done before 5 p.m. All right, let's tootle along here. Looking at the time here, I've got to tootle on a bit quicker. So appraisal condition, real simple. This is where the lending company is going to ultimately decide whether or not this is a good deal for them to lend X amount on this property. And just a note here, if we get an appraisal that comes back and we firmly believe that it's not an accurate appraisal, then we can question it. Obviously, you'd have to first of all go to the lender, If you get no, if you've got really good comps that clearly say that, you know, this is not done properly, you can appeal and to the licensee, and if you're correct, they will overturn it. The important section here, though, is that the buyer is going to make this conditioned on having an appraisal or not. It's a little bit risky if they're going to say not. Just make sure they understand that, because if you know, if there's a shortfall, the appraisal comes out, you know, and there's £5 grand there, then someone has to pay that, and it will most likely, obviously, be the buyer if they've put here that it's not conditioned on the appraisal. Any questions on that slide? Okay. Anybody there? Do I hear anybody or not? No. Financing. Let's talk about this one briefly. Who'd like to cover this one for me? 8.3. Well, obviously, if we are the seller, it's pretty good if we got that little box A checked, isn't it? Why is that exciting for us if we're the seller?
Because then we don't have to have an appraisal.
It's great. Yeah.
We've got cash.
Yes, so that's pretty exciting. However, stay with me, Elizabeth, because most times we are checking B, aren't we? And what does that mean?
We're getting a loan.
Yeah, we're going to get a loan. And this whole property purchase is conditioned on us getting some financing from someone who's going to lend us the money. So just make sure that we understand what we're checking off here. In that B1, we've got buyer's right to cancel before the financial appraisal deadline. Okay, we group those two together. And then we've got in B2, buyer's right to cancel after the financial deadline. And then, of course, we've got the B3, which is the earnest money deposit that will be released to the seller, you know, if we fall within those parameters. Anybody got any questions or comments on that slide? Okay, we've got a note there. Generally speaking, what are we going to place in that B1 dollar section? Do you want to stay with me on that, Elizabeth? What we hoping to put in there if everything is in line with this contract?
On B1.
So yeah, B1.
Oh, well, we're hoping not to cancel, but if the appraisal is to say it doesn't appraise for enough, then we might be canceling and getting our earnest money back.
Yeah, perfect. So hopefully we want to have a 0 in there, hopefully, unless we've had some
0.
Yeah, perfect. All right, let's go to additional earnest money. Sometimes we might have a REPSI that we are going to be adding in some additional earnest money. But why might we do that? And this is a particular market that may see more of additional earnest money than otherwise. Who'd like to talk to me about that one?
Well, we're trying to make a stronger offer if we do that. But I found now the way we're making stronger offers is that appraisal floor addendum, which is a Bearcat, because, you know, we make our price on the home, and then if it doesn't appraise, we say the appraisal gap, we're going to bring extra cash in for a buyer. Anyway, it's made the market really tricky right now.
Mm-hmm. Yeah,
because buyers have to hold out extra money.
And it also depends on just exactly where, you know, your transaction is, and what type of house it is, and how fast those houses are going in that market. But certainly, sellers do like to see some extra earnest money coming in at different stages. It gives more commitment, obviously, from the buyer, and particularly if that earnest money is going hard in good date platforms, it can be very attractive to make these offers stronger. Okay, let's go to the addenda. Let's talk a little bit about this, because sometimes we can forget how important these are. So sometimes we may have an addendum that will go in with the REPSI. And who'd like to talk to me about examples of what that might be?
Well,
just chime in. Yeah, carry on.
Okay. There's always where you will deposit your earnest money. And then there's also the one I was just talking about, the appraisal floor addendum, which is a newer addendum, which is making life tough to get your offers accepted. I'd say most of Salt Lake County is, I've just had put so many offers in where we just get bid out because they have more money for the appraisal floor. They can close that appraisal gap. So just addendums like that.
Okay, very good. And tell me, how important is it that we clearly identify the title of these addendums?
Very important.
Help me understand the reason why. Maybe I'm the title company who's receiving these.
Because sometimes the title company or the other agent won't read real carefully, but they need to, if they see exactly what the title is, I just feel like they read it more carefully. Okay, good.
So a couple of things to think about here. Obviously, make sure your addendums are clear. They're clearly understood, that they're not wishy-washy, as we say in English. They're just very clear what both parties are agreeing to. Make sure you've got either a title for that addendum. I mean, obviously, you've got a couple of options here. If you've got the seller financing addendum, you may have included with your REPSI or FHA loan addendum that they've got titles. Most addendums will have a number or a letter, often a number, but make sure they're sequentially done. Sometimes when we're working with multiple different clients, different transactions, we can get muddled with which addendum we're on for which client. So just make sure that you carefully check that number 1, number 2, number 3, number 4, they're going in sequential order. What you do not want to do is, you get muddled up. And you should be on addendum 3, but you put addendum 4 or you've done an addendum 2 and you've forgotten which number you're on, because that does mess things up with title. Then you have to have an addendum to correct the addendum. So just make sure your addendums are in sequential order if you're running with numbers. And on this item here, of course, we're going to say, yes, we have included an addendum, or no, we have not included an addendum with this REPSI. Just make sure every time we're going to change anything to do with the REPSI or anything that's attached to the REPSI, which can be any of the addendums or documents or whatever is part of this REPSI, if we're going to change anything, it must be done in writing, and we do that with an addendum. We don't cross anything out or, clean out. We don't mess up the paperwork. We always add an addendum to change. Really important. And when you do that, always copy in the people that are involved in that. Obviously, every time you create an addendum, you're copying your title company and your loan officer. Just make sure that you're keeping people in full knowledge of how this transaction is progressing. You'll find that will be much easier by the time you get to the end of the journey, that they've got all of the documents they need, and you've not got title company calling and saying, we don't have addendum 3, or we noticed that this addendum is talking about another addendum and we don't have this addendum. Okay, so just make sure you're really clear as you build up this transaction compilation of documents, that they're all in order. Any other questions or comments on that slide? Okay, make sure you use an addendum to change the REPSI. Okay, home warranty plan. This is quite a good little section, really. Obviously, that home warranty plan is going to include protection against sort of major defects. It's a really good idea to have these. And depending on what market we're in, will depend on who is going to pay for this, or whether or not we're going to have one or not. Generally speaking, in this market, you're probably going to have buyers that will be interested in paying for this. If we're in a buyer's market, often you'd have sellers that will be interested in paying this. So what you've got here, you've got 3 little pieces the puzzle, really. We've got who's going to, well, are we going to have one or not? And then who's going to order it, and which company is going to be selected and who's going to pay for it. That's what we're going to check in there. Anybody got any comments or questions on this slide? Anybody like to comment on 10.2 for me, where it says buyer acknowledges and agrees that in reference to the physical condition of the property, buyer is purchasing the property in its as is condition. What does that mean? Tiffany, how would you like to chime in on that one for me?
Well, I mean, some people choose not to get the home warranty, and they'll take the home as is, and it's neither here nor there to the person buying it. I normally try to see if the seller will throw in the home warranty plan that's chosen by the buyer, or chosen, you know, if the buyer's let's say the buyer's a first-time home buyer, then I will give them a few choices of who I've been through before or suggested before. And hopefully, you know, you're trying to protect your buyer, you know, when you're trying to get this, when you do the home warranty plan, that's part of, I believe, your fiduciary duty to suggest to them to get a home warranty, because oftentimes people will buy a home and then chances are, you know, 2 weeks into the new home, they have a problem with, you know, water damage or something happens. And how awesome is that for a buyer, a new buyer, to say, you know, well, I'm so glad that the agent suggested that we get the home warranty, because now we're covered.
Yeah, perfect. And the good thing about the home warranty, you'll notice the language there, shall not exceed. So you can put an amount in there. If it was $400, for instance, it's not going to be any more than that. If it ended up being more, then you're only paying the $400. So you know what your commitment is. And I agree with Tiffany. I've often tried to get the sellers interested in paying for that. It's sometimes good to see something coming from both sides with transactions, and both parties feel like they're getting a good deal. And this is one area where the seller can certainly help the buyer feel, you know, like they're looking after them. But it does depend on, you know, the types of markets we're in. Perfect. Thank you, Tiffany, for sharing that. Great. We'll toodle on here. Condition of property. Of course, we've covered this a little bit. But if you are representing the seller, for instance, this little section here clearly says seller acknowledges and agrees. And at the end there, it goes on to say that, you know, that they're going to do this broom clean business. What does broom clean mean? Who can tell me what that means? Where we've represented a seller. How do we explain what broom clean means?
In my experience, it is not nearly up to the standards that most buyers want. You know, I think a lot of times they're expecting like a pristine, clean house, but all it really means is that it's just generally the stuff's gone, that they're not leaving huge messes.
Yeah, it's so we can get the broom all over the floor or the vacuum over the carpet, that we've not got any debris or trash or boxes or whatever lying around. That's really what it means. But it does mean that they are leaving the house broom clean, which is clean. So just make sure that everyone understands what that means.
Stephen?
Final walkthrough. Yes, fire away.
Sorry, it's Christy. I just want to mention something about broom clean.
Good.
I had an agent tell me that their own interpretation of broom clean was my interpretation of broom clean. So they left a big mess for my buyers a couple of years ago, and there was no recourse for me. So it's all contingent upon what your agent believes broom clean means. There is no definition.
Yeah. Well, unfortunately, you are right. Different people have a different concept of what it is. But if it's broom clean and someone asks you what the definition is, it means you're able to take the broom and you can clean up, and whatever it clears up off the floor, it's gone. But, you know, if you've got bits of bike and bits of furniture left that should not be left there, then that is not broom clean. That should be taken out of the.
Yeah, I know.
The challenge is we find in the garages, there's usually a mess because they've not swept it out. And then we go and try and put stuff in the trash cans and they're already overloaded. And unfortunately, you know, the refuse guys came the day before. So now that new buyer has nowhere to put their stuff. They've got to go and take it to a refuge centre, and that can be very, very uncomfortable for the new purchaser. Yep. So we've got to just try and do our best to help people.
It was.
Can I interject something there, Stephen?
Yeah.
I had a situation like this as well, where my buyer, you know, they were so excited to get into the house, and Broom Clean, they walked in there and it was not Broom Clean. It was a fiasco. And I was a new agent at the time, but that was a great lesson for me, because I learned that when you do that final walkthrough inspection, when you go through and do the final walkthrough the week before, you check things out. You make sure that, you know, they're not leaving all kinds of garbage and things behind. And then as an agent, I like to go in a day or two before just to make sure my standard of Broom Clean has been done. Because what happened was I ended up having to hire a professional house cleaning company to come in to make my buyer happy. And on that first situation. So I learned real early on that, you know, nobody wants to open up a house that they've just bought and come into a big catastrophe.
Yeah, you're absolutely right. Thanks for sharing that. And that final inspection there, we can do up to 7 days prior to settlement. I encourage you to go on that. As Tiffany said, go on it with your client so that you can make sure and touch base with the agent, the selling agent, make sure they know what you're expecting as you move into that home. We'll just quickly run through these last few slides as we get to the last few minutes of this this class here. There will be some changes during this transaction, and as we do that, we are basically both the buyer and the seller need to be happy to sign along the way as we do that. Oh, there we go. Someone's got some action going. Alterations, encumbrances and agreements. Very simple, that little section there. It's pretty clear what it says. And we're basically agreeing to all of those, usually on the purchases, the 1 and the 2 of the 12 there. Hopefully this transaction can be comfortable. Make sure you've got people that have the authority to sign, particularly if you're moving into trust estate or a limited company. Make sure you've got the right people signing the right documents, otherwise that can be a challenge too. So make sure you've got the right people there. This REPC, as it continues to build, it's like putting different pieces of the puzzle together, but they're all part of the same picture, all part of the same document. So as we add things or take away things from the REPC with addendums or documents, then it's all part of the complete contract. Just make sure that we know that as we're working with our 2 different parties. Mediation, let's just spend a couple of minutes on this one. Lots of people not too sure which box to check here. There's fors and against for both. I've been with 3 different brokerages during my 13 years or 12 years, whatever it is, and two brokers have preferred one and 1 broker has preferred the other. So I'd encourage you, if you're asked the question by your client, and they say, what do I check off here? Before you give counsel, make sure you're in harmony with the broker, because this agreement is between the client and broker. Make sure that you are giving the right advice. So shall or may, at the option of the parties, be submitted to mediation. Anybody want to comment on that slide before I move on? Anybody know the difference between the 2?
Stephen, I think I always check shall, because when you check may at the option, that gives them an out if you ever have to have an out. So, and then they might fight it. So I always check shall. That's what my broker preferred.
Mm-hmm.
Yeah, just make sure your broker's comfortable with it. I can't give advice either way. The difference, of course, if you do shall, they're both agreeing they're going to go into mediation with the third party. Right. They will obviously pick up any of their personal expenses on that, but generally speaking, that will be less difficult. No, that's a wrong word. It'll be cheaper and it will be less hassle. That's probably a better way of putting it. But sometimes the mediation will not satisfy all the concerns. It doesn't dig deep enough. So that may be a challenge there. Going for the may have the options for mediation gives them the opportunity to decide whether or not they're going to mediate or not, or go straight into the courts. Of course, that's going to cost a lot more money, but they do drill deeper down into the situation. You will get a court judgment on that. So just make sure that the key thing here is to talk to your broker for the best advice to see what they are comfortable doing. Then you can advise your client, but ultimately it's your client's decision as to which one they're going to check there. Just make sure they understand so that they're making the best decision for themselves. That's the key thing. Default, of course, you know, if we don't meet the requirements, then we can default the contract. I think someone mentioned this earlier on. And of course, if it goes to court, one party can sue the other, and it will depend on who's defaulting. So if we're not meeting the requirements, then, you know, this can go to court, and all of the expenses will be paid for by the person that loses. Attorney fees and costs, government law, that's what we are signing off here. And all of those, of course, will survive the closing. So we are Utah law here. Any notices must be in writing and obviously signed by all buyers and all sellers. You can't just have part of the team signed. So anything you're going to change here, any notice have got to be signed by both. We're not going to assign this to anybody. It is going to be just between the two parties. It's non-assignable. Insurance and risk of loss. There's the one little section here. Let's see where it is. Oh, there it is. It's the 10% area. There it is. So if for some reason it all goes a little bit strange and a lot of damage happens, it says there, borne by the seller, provided, however, that if the cost of repairing such or damage would exceed 10% of the purchase price, then seller or buyer may elect to cancel the REPSI, provided written notice to the other parties. So in that instance, the earnest money or deposits would be returned to the buyer. So the 10% is the key part there. If you know, there was a fire or an earthquake or whatever. Make sure you got those signatures signed again as we get to the end of this little contract here. Time is of the essence. We have covered that today pretty well, which is that 5 p.m. Mountain Standard Time. To make sure we all got that in our heads. When I first got involved in this industry, in my head, it was midnight until I looked at, oh, it's 5 p.m. I've got to make sure I be sharp enough. And as someone said earlier, it might have been Mandy, I can't remember, but make sure you're on this at 4 p.m. so you can tidy everything up and everybody's happy and we don't lose, you know, any earnest money. Electronic transmissions, great in this part of the world, in this part of the 21st century. We all are happy that we can get through these transactions by having people electronically sign, which is a lot of fun. Acceptance, of course. Make sure when you're working with that counter offer that you're falling within the deadline dates. Here comes our third keyword as we finish up this little round. It looks like it will be acceptance. ACCEPTA, ANCE. Acceptance is your third keyword. But the two keywords have been given. If for some reason you missed them, talk to Leslie Ann privately through chat and she will be able to help you if you've qualified in all the other platforms there. Acceptance is the third keyword. Contract deadline dates. We did briefly talk about these earlier. Just make sure you've got enough time in between these dates to do what you need to do. Seller's disclosure should be able to do fairly quickly. Due diligence, we talked a couple of weeks, usually there, probably another week on top of that for your financial and appraisal deadline, and your settlement deadline. You can get these transactions done within a month, but just be aware that you're making good choices when you're choosing those dates, so you don't have to keep amending them if things are going a little bit crazy trying to meet them. That can be frustrating to the buyer. Sorry, to the seller, if they're having to adjust because you've been too keen on those dates. So just be aware of those. And of course, there it is again. We have got an opportunity here to put in a time when we're putting in counter offers or acceptance to such. make sure you put a time that will work. If you've got a buyer where you've got half the team that's working nights and the other half team's working days, or out on business, traveling, make sure you've got enough time to give them so that they can have these signatures done in time. Otherwise, you've got to redo them. And there's your full signatures at the bottom. I think that closes up. Oh yeah, we've got that last bit there. There it is. Just make sure you understand we've got 3 options there: acceptance, counteroffer, or rejection. Just make sure you fall in line if you are going to meet whichever one you have chosen there. Okay. Remember your number. Yeah, that's good. Very bottom there, it's clear that this particular form was updated in 2017, and all pretty good forms these are. Last initials at the bottom of the page. There we go, folks. We got through that. We've covered everything in the last couple of hours. I finally got in there before we hit that midday time. So I would like to get on time when I'm closing these. Leslie Ann will share with you a form. Will be actually a little link to a form. I'd encourage you to click on that now if you can, and enter those keywords and put your detail in there. Follow the form carefully because I will copy and paste your detail into the division. Well, we work through Pearson VUE. Everybody works through Pearson VUE. We work with the division. If your name is not spelled correctly or your license is not done correctly with numbers and letters, then it will not go through. That's what we covered today. And hopefully Leslie Ann will be with us in a moment. I'll put one note there in red. Please contact us within 5 days.